The key thing that both buyers and sellers need to do is to have a frank conversation with each other as to what are the risks that can come about between signing and closing, and let's actually have a conversation about what could go wrong and how do we allocate risk if things do go wrong. A classic example of that is a material adverse effect clause, which is a clause that generally practitioners and companies have been willing to allow courts to decide the interpretation of whether or not something that goes wrong is or isn't a material adverse effect. And I think that we've seen that by leaving those decisions to courts, buyers, for example, may not be getting what they thought they were getting in the way of protection. And so what I've been advising clients is if you think that there's something that you want to address, let's not rely on general legalese or boilerplate contract terms. Let's have a discussion about that risk, and let's talk with the other side about who's responsible if that thing comes about. I think that, you know, especially in deals, there can be deal momentum. Both sides want to get something done, and sometimes there can be a fear on either side that having a conversation that's very difficult could lead to unintended consequences. Maybe the deal falls apart, maybe it leads to a revisitation of a price discussion or something like that. And I think that what we've seen in some of the deals that fell apart in '07 and '08 is by avoiding that hard conversation at the time, you're really putting yourself at the mercy of a court or something else to determine whether or not, you know, you're on the right or the wrong side of the argument.